Okay, let's get going here. We are in we're in the Orange Manual. This is real estate, Colorado Real Estate Contracts and Regulations. This is for the pre-licensing and also for the 24-hour broker administration and the reintroduction course. As long as I don't lose my voice. And this is lesson 6. And let's turn to chapter 10. I'm talking about title. We talk about title virtually every session in pretty great detail. Now, the first type of title we'll talk about is an abstract and opinion. Now there's two words that tell us we're working with an abstract and opinion, and that is chain or history. Chain of title or history of title. Question on the state exam says a title policy was ordered that showed a history of ownership. This is more than likely an abstract and opinion. The opinion part of it means an attorney's opinion. An abstract and an attorney's opinion. We don't order abstracts anymore if you're working in Denver. You'll see them on the western slope and out on the plains, but you're not going to see them in Denver. Ordered. You will see them out there. You will see them out there. My fishing buddy, his mom died a few years back, and she had a home that was built in 1925. And after the funeral, he came by my desk and said, "What's this?" and threw this abstract on my desk from 1925. And if you've never seen an abstract and you're a history buff, you'll love them. You'll love them. If you're not a history buff, become one. I tell you what, it's I can't get enough of it. And this particular abstract, 2 hours later, I was still reading it. It went all the way back, almost to Columbus, discovering the United States, almost. Talk about when this was done by Gates Rubber Company, and when Denver annexed that area, I thought, shoot, I thought that was always a part of Denver, but not really. I found out that Denver used to be a part of the Utah territory. You guys know that? Kind of wild, kind of wild. Things like this, and these abstracts again are interesting, but they just show a history or chain of title. Doesn't necessarily show how much ownership was passed, etc. Go to page 10-2, and this is what we actually use is the title insurance, the actual title insurance. Now look at these 1, 2, 3, 4 down here. Those are the exemptions. Remember I told you there's 6 of them. They only mentioned 4 here for some reason. When we go to the purchase contract, we'll go over all 6 of them. Remember, it's going to cost about $40 to $60 to insure over the standard exceptions or exemptions, whatever they want to call it. And again, there's 6 of them. We'll look at it when we get to the contract. And actually, the title company can override the contract and say, we don't need to have this insurance over there. There's nobody living on the property we have to worry about adverse possession. There's nothing weird going on. We're not going to require that. So it's up to the title company to make the final say. And then we have, and there's 2 types of main insurance policies. There's the owner's policy or seller's policy, and that's the expensive one. And typically the seller provides marketable title. The buyer can, whoever orders the title pays for it. So this owner's title policy runs, let's say, $1,500. Well then, look on top of page 10-3, the mortgagee's policy. Who the heck's the mortgagee?
The lender.
The lender, the money, the mortgagee. One way to remember it. And the lender goes over to the borrower and says, "Mr. Borrower, we need a title policy also. And the reason we need one, help me out, why does the lender need a title insurance policy?"
Guarantees their security. Interest in the property.
No. Remember, the lender needs a title insurance policy because they're selling that note to the secondary market. They're selling that note to Fannie Mae, Freddie Mac, or Ginnie Mae, and they will not buy that note unless it's in first position. First position. What's first position mean? The first one to be recorded. And so, Mr. Buyer, you can get another policy that's going to run $1,500, just like the seller just bought, or you can get a spin-off policy that's going to run you $150. What do you want to do? It's such a no-brainer, they don't even ask. It just shows up on our settlement statement as the owner's policy and the mortgagee's policy. But guaranteed question on the state exam, who pays for the mortgagee's policy? The borrower. The borrower. Remember, a lender never has any fees. They always pass it along to the borrower. At a closing table, neither the lender nor the broker has any fees in a perfect world, right? I've had to get out my check more than once to make a closing happen. Sometimes you got to do what you got to do. So again, we have our main title policy, and there's two parts to it, the owner's policy and the mortgagee's policy. Now, if you're going through a credit union or an owner will carry, it's not going to be sold to a secondary market. If it's a commercial property, it's not going to be sold to the secondary market. You're not going to have this mortgagee's policy. But if you're sitting at that closing table and somebody says, how come there's two title policies? You guys are going to be the only ones sitting at that table who know. You're going to be looking pretty darn good. So remember that. Remember what that's for. Any questions on that? When we get to financing, we talk about the secondary market in pretty good detail. This next part talks about a title insurance commitment. And it talks about 4 lines down in the middle in that first paragraph, something called a TBD, to be determined. Now what that is the actual title insurance policy, and the only thing to be determined is the people's name on it. Maybe I want to look at this title a little bit deeper before I buy it. I'm the seller. I want to look at it a little bit deeper, or I'm buying the property. And these run about $100 for these TBDs, give or take. And you get them through the title company, and that money applies toward the actual title insurance. But again, it's a TBD. Remember that. Keep in the back of your mind, because sometimes you have a question about the title, and you need more information. Just remember that these TBDs are there. Now, go to page 10.4 and look at the second paragraph. This is how we do it in real life. Title companies give sufficient information in the form of an ownership and encumbrance report, or O&E, to allow a licensee who has a listing to perform most necessary functions. Although title companies also must charge for O&Es, the cost is often far less than that of a TBD commitment. So again, a TBD runs $5. Runs $5.
On the O&E, like for instance, for my client who had her grandfather that passed last night, about a year and a half ago, her grandmother had passed. So would we need to pull an O&E and a copy of the deed to see if the grandmother was still on it?
Very good. Did you hear that? Say that again. I like that.
The grandfather
Mhm.
passed away. Grandmother died a year and a half ago. So they were asking all these questions last night about, assuming the loan and everything, but because the grandmother, I was just thinking about it, the grandmother that passed away a year and a half ago, if they never got her off of the deed, isn't that going to be a little bit harder without the death cert, like if they can't find the death cert or something like that? Or
Exactly.
so if they pull an O&E now, they're no
Pull
kind
the
of,
O&E now, where you got it. Were you going for a listing when that happened, or what were you doing?
well, we're trying to get the granddaughter to assume the loan.
Oh,
So we
okay.
just were trying to see what troubles that we could have when this, because you have to go through the current servicer, so it's best to have all that probably information up front.
You're having her assume the loan, really?
Where we're trying to. Because the payment's only the interest rate's 3 point something.
Uh-huh.
The payment's like 11 something, which was in her price range, which she was going to pay
She
for.
has to qualify for it, though.
Right. And we think that she can, but
Well, how much time is left on the note?
there's probably 20. He'd refinance, so.
Well, I'm going to. The reason I'm asking, let's say there's only 10 years left on the note.
Oh, it's not like that.
It's like
Yep.
a long time.
Yep.
Okay, so why am I asking this? Because she might want to get a new loan that she qualifies for, and have it stretched out farther, possibly,
The
rather
interest,
than
yeah.
paying it money up front and assuming the note.
the interest rates
So-
are higher now, so her payment would be higher. So there's no way she could qualify.
Good. Because so now she can. And why are the interest rates higher now? We're in October. October is the #1 month of the year for closings. Typically. There's more closings in October than any other month. And of course the demand, because there's more demand for that money, the interest rates are always higher. Interest rates are always higher through the summer. I shouldn't say always, I hate using that word,
Right.
but usually, typically, you can count on them being higher because there's more demand for them. When are the rates the lowest? December, pretty much, from Thanksgiving on till the end of the year. People say, well, I'm gonna wait till after the first year to put my home in the market. I tell them, are you kidding me? You don't have nearly the competition now. Get that home in the MLS, you kidding me? You better believe it, I love marketing homes in November, December. I love showing buyers homes in November, December. Anyway, something to think about. Now, look on page 10.5 and look at that fourth paragraph from the bottom down there. And here we talk about good funds again. Like I said, they love repeating themselves. And just that dark print, I'm just going to put your attention to that. Everybody see that? Available for immediate withdrawal as a matter of right. That's the definition of good funds. I can get my hands on it today. Then the third type of policy we have what? Abstract and opinion, with an attorney's opinion, abstract and opinion, actual title insurance policy, of which there's two parts typically, the owner's policy or seller's policy, and the mortgage ease policy. Then we have a torrent certificate, page 10-6, torrent certificate. We talked about this a bit yesterday. A torrent certificate works the same as a quiet title suit, where I want to clear this title, get the liens off of it. I will go to the court, and the court will put an article in the local newspaper saying if anybody has a claim on this property, come forth. And if after a period of time nobody comes forth, then they clear the title. That's how a torrent certificate works. It's only used in 10 states, and Colorado is one of them. You use this out on the eastern plains of Colorado, where maybe the county's only open 2 or 3 days out of the month. There's no title company in the world that's going to stand behind those documentations there. So again, the torrent certificate. So there's 3 types of title: abstract and opinion, the actual title commitment, title policy, and the torrent certificate. Those are the 3 types of title we recognize in Colorado. And yes, you'll have a question or two on the state exam about torrents on the Colorado portion. Probably nothing on the general, because it's so rare, but you very well could. Okay, I'm turning that heat down. Right there.
Turn the heat on?
Down.
Why would you turn the heat on? Just shut the air.
Push that to 70.
It's not like freezing.
Hey, what do you mean?
Okay, let's look at chapter 11, guys, appraisal regulations. And appraisers, on the Colorado portion of the state exam, there are no questions about appraising at all, none. On the general part, in the general portion, law and practice of the state exam, there's 10 questions about appraising. So it's very important that you understand appraising, but we're not going to do anything with this chapter. Appraisers were required to start getting licensed in 1991. Anyway, so appraisers, there is a requirement for licensing of appraisers. And that might be the only question you might have on the state exam for the Colorado portion at all. Same with chapter 13. Skip chapter 12 and go to chapter 13. We have mortgage loan originators, and yes, they are licensed. And they've been licensed since 2008. Since 2008. And what happened is in the year 2000, I was actually on the board of directors of the Colorado Association of Mortgage Brokers, and our people who belong to the Colorado Association of Mortgage Brokers kind of split down the middle, whether they wanted licensing or not wanted licensing. So we just kind of stayed neutral ourselves as a board. Well, one day, one of the state senators came to us, and I guess his wife had been jacked around by a mortgage broker, and he said, "You guys will either license your industry or we'll do it for you." We said, "Cool, we're ready." And so what happened is we did hundreds of hours of man hours to get this whole platform ready, and we had to have it into the state in the sunset law by July 1st of the year 2000. And it sits in sunset for 16 months. During that time, people can add to it or subtract from it. And it came out of sunset in like October of 2001. It was supposed to be the first thing before the state senate in 2002. And what happened is about then some other organization had this stupid lending law they tried to get through that would have shut down lending in Colorado. They just would have stayed out of it. Ours would have taken care of everything they needed to get done. We had to stop ours and go after the stupid one and get rid of it, and we did. Then we went over to get our bill to introduce it, and nobody could find it. What happened is Tanzanaka, who was the head of the Senate, he's out of Fort Collins, was sitting on his desk up there. And we finally found it up there, and one of the guys from the board, who was on the board, and he said, "Can you call him up there and tell him to get it down here?" And I said, "I don't know them up there any better than you do." And I said, "I'll give him a call." So I gave a call up there, and I got a hold of the guy's executive secretary, who was a wonderful lady. And we had that back to us in just a couple of days, but it was too late to present it before the Senate that session. Just a heck of a mess. So we didn't get the licensing in 2002. And during that time, Governor Owens was the governor then, and he was being very heavily influenced by the Colorado Mortgage Lenders Association. That's the bankers. They're the guys with the money. Mortgage bankers have a whole lot more money than mortgage brokers do. And what happened is he was totally against any licensing for mortgage brokers. And so we didn't need his endorsement, but we didn't need him working against us. But what's happened, of course, DORA, Department of Regulatory Agencies, who controls licensing, is like a cabinet post for the governor. And they were and of course they were against us getting licensed. They wouldn't support us. They were totally against us getting licensed. And so what happened is that during that 2002, I got a hold, Rick O'Donnell was the head of it then, and I got a hold of his deputy, and I said, "Can we come in and just talk to you guys?" He said, "Yeah, come on in." So a couple of the guys who were on the board and myself, we walked into Rick O'Donnell's office. And these people could not have been more cordial. And they sat down with them, and they said, "Guys, we got marching orders from the governor. We can't support this licensing for mortgage brokers." And even at that, they gave us an hour and a half of their time. And afterwards, we said, "We know you can't endorse us, but could you stay neutral?" And they kind of looked at each other, kind of encouraging look. And we thought, cool. We didn't need their endorsement either, but we didn't need them fighting against us. And so what happened is about 3 weeks later, we had this meeting at the Capitol building. And after a couple of hours, we took a break. And during those 2 hours, nobody from DORA, everybody knows DORA is Department of Regulatory Agencies, nobody from DORA had shown up. And we took a break after a couple of hours, and during the break, 6 representatives from DORA walked in. And we went, "Oh, here we go. The battle's going to start." And the meeting went on for another couple hours, and those guys sat there and never said a word, stayed totally neutral. And we went, cool. And so what happened is that happened in 2002. 2003 came along, we were going to introduce it, and we had all the Democrats on our side. So we started whining and dining the Republicans to get them on our side, the congressmen and senators from the state. And the last day of session, it went before this one committee who was going to decide whether the licensing was going to go through, and this committee was headed by a Democrat. And we went, cool, we got it. And this Democrat stood up there, and I couldn't believe it. He said, because of the bipartisanship of this issue, he was telling us we didn't kiss the Democrats hard enough. Unbelievable. He said, because of the bipartisanship of this issue, for the first time in my career, I'm voting against something I'm for. And killed us. And that I almost have to, just hard to believe. That's 2003. 2004 came along, and within about first 2 weeks of session, we got a letter from the governor, Governor Owens, saying, if anything hits my desk about licensing mortgage brokers, I'm going to veto it. So that killed us for 2004. 2005 came along, and we just thought, we're just going to let it cool off, because it was a hot issue. And during that time, the governor threw this big party over at his mansion and invited some of us to come to it. And it was pretty cool, nice party. But that night, Governor Owens had a few too many. He was feeling no pain. And he was kind of over in the corner talking with people. And so we kind of nudged our way over there. And we went up to him and, and introduced ourselves. And we said, we're from the Colorado Association of Mortgage Brokers. And we said, Gov, we didn't call him Gov. We were trying to get these licensing going and everything. And he said, I can't endorse it, guys. I don't have the initial funding to get it going, and I can't support it. And we said, would you at least possibly consider registering them? Because at that point, only Alaska and Colorado were the two last states that didn't have any licensing for mortgage brokers. And he kind of went, I might be open to that suggestion. And we held him to it. And in 2006, we got it through where we had registration for mortgage brokers. And we had 10,500 mortgage brokers in 2006 sign up to be registered. Whatever that, you register your dog, you know. But we registered these mortgage brokers too. Then in 2008, we finally got them licensed. And in 2008, less than 4,000 actually got licensed, which means between 2006 and 2008, over 6,500 mortgage brokers disappeared. You know, that's when everything went down the tubes, was between those years. Right now, there's right about 4,000 mortgage brokers that are licensed in Colorado. But yes, they are licensed now. And that's another question on the state exam. Are they licensed? Yes, they are. Now, you guys know more about how that happened than anybody. And it was really, it took us 8 years. 8 years to get them licensed.
The first mortgage I ever got, the mortgage broker was somebody who was really nice, but I was so young, I was like 22, and I didn't realize that she didn't know what she was doing. And if she'd been licensed, everything would have been better. I think. I hope.
Well, see, mortgage brokers don't loan money. They're the conduit between the consumers and the banks.
Yeah.
And
It
before,
took me a while to figure that out.
yeah, before licensing kicked in, before 2008, 42% of all lending was done by out-of-state lenders in Colorado. You lose your license in Arkansas or Florida, well, let's go do some lending in Colorado. They don't have licensing. And it was a Wild West out here back then, pretty wild.
Well, we needed an unconventional loan because we had a business that was less than 2 years old, and we were both young, and we didn't fit. You know, you weren't going to be able to sell the loan, so we weren't normal.
I'm
But
glad
we
you-
didn't know that.
I'm glad you brought that up, Kim, because what we're saying here, once you get your real estate broker's license, guys, and you want to get a home, you know, this is your own business. You're a subcontractor, you're not an employee, and you have to have 2 years on that job before you can get any type of loan. Because that's what a Fannie Mae and Freddie Mac requirement, and Ginnie Mae requirement. So what do you want to do? Go to lenders that don't sell it to the secondary market. And that's what Kim was talking
That's
about.
what we finally did.
So you go to credit unions or First Bank. First Bank is a portfolio lender, is what they're called. They don't sell their notes to the secondary market, so they don't have to play by their rules. So anyway, there's always a way to get things done. There's always plan B. Let's go to page 14, chapter 14, I should say, and talk about water rights. Water rights. Now, about 4 years ago in this manual, they added about 5 or 6 pages to this chapter, and they took out the pages that had the questions that are on the state exam. So I'll tell you what questions about water rights are on the state exam. Well, let's talk about, and water rights in Colorado are handled differently than any other state. In Colorado, water rights are considered real property. Water rights have their own separate legal description, and water rights have to be transferred with their own separate deed. With that as an introduction, let's look at the top of page 14.1. It talks about water allocation laws and procedures. All water and natural surface streams and groundwater and related aquifers called tributary groundwater in Colorado is owned by the public and is subject to the doctrine of prior appropriation. What does that mean? First in time is first in right. The first one to use the water is the first one who has senior water right to use that water. Groundwater other than tributary groundwater is allocated by different rules as described below. There is a rebuttable presumption under Colorado law that all surface water and groundwater in Colorado is tributary to a natural surface stream. A water right is the right to use a portion of the state's water. You don't own it, you just use it. A water right does not represent ownership of the water. It is a right to use a certain amount of water for a particular purpose under the restrictions stated in the court decree or well permit defining the water rights. The first one to use the water has a senior right, not to record it.
I thought you said water rights were considered personal property in Colorado.
No, they're real property.
Oh, real property.
They're real property in Colorado, not personal property. They're real property. If I sell you my ranch and I don't say anything about my water rights, you didn't get my water rights. They have to be transferred separately with their own separate deed. Now, the doctrine of prior appropriation is adopted and recognized in the Colorado Constitution in Article 16. Do you need an Article 16? No. Section 5 and 6. Prior appropriation means that the first user to divert water from a stream and put the water to beneficial use has a prior right to that source of water compared to later users. Under the prior appropriation system, water users do not share the burden of shortages. The prior user is entitled to divert the full amount of water to meet his or her entire water needs before the next junior user is allowed to divert any water. Isn't that something? That's why these senior water rights could be worth more than the entire property. Could be very, very valuable, especially in Colorado, because we do have our limitations on water here. Now,
But
how about wells? Are wells considered water rights? Wells get their water from underground collections that are called what?
Aquifer.
An aquifer, underground aquifer. Let's flip to the next page. Next page. And it's an underground aquifer, and that's where water is collected. And when you drill a well, it taps into that aquifer. Now, wells are not water rights. Now, there's some big commercial wells that could be, but generally, a well is nothing but a utility interest. Calling a water right, calling a well a water right is like calling the water that's coming in your house from public service a water right. No, it isn't. It's just a utility interest. Does that make sense? So, let's look at page 14.2 and go to the fourth paragraph. It says, water rights are administered, meaning that they are enforced by the state engineer's office. Water rights are enforced by the state engineer's office. Go to the bottom of page 14.3, last paragraph. Let's read this paragraph. A well is any structure or device used for the purpose or with the effect of obtaining groundwater for beneficial use from an aquifer. A permit issued by the state engineer's office is required to construct a well, except in designated groundwater basins where the well permit is issued by the Groundwater Commission. And the state engineer's office maintains records of all well permits issued in the state. There was a confusing question on the state exam that said, where do you get a well permit? And one answer was the state engineer's office, and another one was the Groundwater Commission. We can get it from both places. That question has been cleaned up, but I still have it kind of diluted in your finals. Just so you see that question, you'll nail it, and then when you see it on the state exam, you won't have any problem with it at all. So again, we get our well permits from the state engineer's office, and they are at 1385 Sherman Street. Just put that down. And the reason you need to know that, 1385 Sherman Street, because in our contracts, which we're going to go over next session, what's going to happen is we're going to find out that anybody who's selling the property who has a well that they're using for their utilities, okay? We have wells in the city where they just use to water your lawns. There was a time, well, last time they did this was like 20 years ago, where we had watering restrictions, where only certain addresses could water on Monday and different ones on Tuesday. And people who had wells where they could water it had signs up in their windows saying, we're using a well, no report us, type of thing. But if you're using the well for your water for your house, you have to prove you had a well permit. And before 1984, a lot of people didn't have to get a well permit to drill a well. But now if you're selling your property and it has a well on it, you have to get a well permit. And the seller, it's up to the seller to have to go down to the state engineer's office and get that well permit. On a well that was dug in 1978, whatever.
Oh.
Yeah. And so you've got to tell them that, yeah, you got to go down to Sherman. This is right in the contract, guys. Right in the contract. that says you can't get a loan on this property, you can't transfer the deed, nothing, until you get a well permit on that property. Now, there are two kinds of wells. There's a domestic well, and everybody's heard of that. You know, you can use the water for anything you want to, pretty much as you want to. Then we have what's called a household use only well. And those types of wells, you can only use it for interior housing use. You can't legally water a plant on your front porch. You can't wash your car in the driveway.
What's it called? A what well?
It's called a household use only well. And most wells are household use only. And you sure as heck can't have horses. Now what happens is that you're out selling property to these people and they want a horse property. You check the zoning and everything's cool for the zoning, and they go move into the property, and a month later, every county has water police. I know that sounds very Orwellian, but yeah, they have water police. Knock on your door and say, we see that you have horses here. You've got a household use permit only on your well. You got a week to get these horses out of here. And most wells are household use only wells.
So if your horse lived inside the house with you?
You go inside the house, you got a mate, you bet.
Well, like some people have pigs and they keep them in the house, and they're crazy, of course, but.
You know, the state law states that for comfort animals, you know the only two that fall under that
Pig and
are
dog.
dogs and horses.
Oh, I thought pig was one too.
No,
Huh.
no, not even cats.
Not even
Oh.
pigs.
Dogs and horses.
Because cats are so
Yeah.
mean.
But anyway, it's funny you brought up that about horses. But I mean, there's all these things about horses, guys. You're going to be doing stuff up in Evergreen and Conifer. You know, in Park County, they passed a law a few years back where they made it where you had to have a minimum of 5 acres to have a horse. Park County runs from Conifer all the way down to Fairplay and that whole area down there, way beyond that even, Buena Vista. It's a big county. And you have to have a minimum of 5 acres to have a horse, but they grandfathered everybody who has a horse now. They could keep it. But when they sell the property, the people buying it had to have at least 5 acres to have a horse. And did that cause some problems? Because a lot of brokers didn't know that up there. And these people want a horse property and they pull up and here's horses in the backyard, horses in the stall. Of course it's a horse property. No, it isn't. It's less than 5 acres.
So where would that be at, that information? Would
Where would it be at?
Title?
It'd be in the title policy. You bet it would be. Yeah. Yeah. It might be in the O&E also.
Mm-hmm.
So again, we got to understand the area we're working in and how the peculiarities of that area are. Look at top of page 14.4, and this is something very few people in our industry know about. And as an appraiser, it was imperative that I knew this. On top of page 14.4, this is called Senate Bill 35. Put that up on top there. That's not mentioned here. It's called Senate Bill 35. And what it states,
14.4.
Senate Bill 35 on top of page 14.4 there, that top paragraph. I'm just going to kind of summarize it for you. First of all, in 1971, they passed a law stating that any land that was subdivided after June of 1972 had to have a minimum of 35 acres or you couldn't get a well permit. That's why we have these 35 and 40 acre mini ranchettes all over, is because you can't get a well permit unless you have a minimum of 35 acres. Now, if it was subdivided before June of 1972, it's grandfathered in, and you're fine. But the Senate Bill 35 again is something that you have to be aware of. Had a student a few years back who had 51 acres up in Evergreen, and his next door neighbor had a parcel of land that had 32 acres on it. Worthless piece of property, totally worthless. You can't build on it. You need 35 acres. So they got to be friends, and he told the guy, he said, why don't you give me 3 of your acres, and I'll let you have access to my property to get into the National Forest, because this guy didn't have access to the National Forest. And right about then, he's taking this course, and he's talking about this. And he's going, wow, that's why the guy needs the 3 acres. And he ended up selling to the guy for $24,000 plus access to the national park back there. And so again, knowing how the system works and knowing your limitations and everything, very important. Now, let's go over to 14.6. We talked about this some yesterday. Well, we talked about, let's read it. Disclosure of the potable water source. Potable means drinkable. On or after January 1st, 2008, Colorado law requires that a listing contract of sale, or seller's property disclosure for residential land and residential improvements disclose in boldface type the source of potable or potable, however you want to pronounce that, water for the property, which can be one of the following. A well, in which case a copy of the current well permit, if one is available, is to be provided. If not, they have to go get one. A water provider, in which case the name and other information regarding the water provider is provided, or neither a well nor a water provider, in which case the source of water is to be provided. But this is, again, the disclosure of the potable water. And here's the actual disclosure on page 14.7. In bold print there. The source of potable water for this real estate is a well or water. Who's the name of the public service company or whatever who's providing this? And we all need this. You
It's
need
just
to
as
get this
important as a
done.
lead-based paint, right?
Pardon me?
This is just as important as a lead-based paint.
This is just as important as lead-based paint. You bet it is. And again, this is something that we have to do.
What made that go into effect? Because it wasn't always there.
Well, mainly because of the shortages of water, especially in Douglas County and some parts of Weld County, where you've got these central wells that are supporting these subdivisions, and they're going dry. And man, I mean, this is a huge problem down there. And they're trying to figure out ways to correct it. You know, that's a tough thing to correct. You got to run water lines all the way from these reservoirs up in the mountains down to them, etc. And again, keep your eyes on this. This is an issue that's really coming to the forefront. Last few winters we've had enough snowpack that we haven't had really any problem with water shortages. But well, I tell you what, you know, Colorado, we go through years sometimes, many years in a row, we have really serious water shortages where those underground aquifers aren't replenished again. I remember when was it? 20 some years ago, I remember reading an article where Texas was saying that all of their aquifers were almost dry. And they're so concerned, on and on and on. And the comment at the end of the article said, what Texas needs is a good old-fashioned hurricane to hit. And right about then, Andrew hit. And I'll tell you what, it filled up the aquifers, but man, you know, there's a trade-off for that too. And now California, what they're going through. So again, water is a huge, huge issue. Let's look at middle of page 14.7 and look at that B right in the middle of the page. If the disclosure statement required by paragraph A of this subsection indicates that the source of potable water is a well, the seller shall also be provided with disclosure a copy of the current well permit if one's available. But again, they have to have one even if it's not available. It's right in the contract now. Now, let's go to page 14.12, 14.13. These are definitions. You need to know these. The ones you need to know are in the glossary, and we're going to go over the entire glossary here in a few more sessions. So don't go in there and spend any time trying to memorize and try to learn these different terms for water rights terminology.
Oh, good.
So we don't really need these for the test?
Don't need it.
Oh,
Don't need
perfect.
those. The ones you need, we're going to cover in the glossary.
Alright.
And when will we need them in real life?
In these, no, unless you're going to be, you know, if you're going to be, you know, there's some brokers who only deal with water rights, guys,
Just don't bring your book.
and there's some money in that. So if you're up in the mountains or whatever, you might want to consider that. You know, out in the plains where you're working with farm and ranch, you bet you. Then of course you need to know this. Let's talk about on page 14.13. See that open space down there? Let's take some notes on this. First of all, let's talk about water usage. This isn't water rights, but rather water usage. Like a municipality, say Wheatridge, they've got so much water that they can use. And what is who do they take care of first? What's the pecking order of who gets this water? The first one, of course, would be domestic/household. That's always number one. Domestic/household use. The next one, agricultural. Could be commercial or agricultural. Let's put agricultural as number two. Number 3, commercial slash industrial. Commercial slash industrial. And the 4th is recreational. Domestic, household, agricultural, commercial, industrial, and recreational are the 4 types of water usage. This isn't water rights, guys. Remember, this is how much the city is, how they're allocating their water usage. Now let's say Wheat Ridge gets short on water, and they have to adjust this water usage, and they want to push that commercial into the place of the agricultural ahead of it. What it will do is condemn that senior use and move it up into its place. Everybody got that? They will so that they'll condemn that agricultural use and move that commercial up in that agricultural slot. There are 4 ways we utilize condemnation in Colorado. This is part of what they took out of the book that's going to be on the state exam. There are 4 ways we utilize condemnation. 1 is water usage, what I just said, adjusting for water usage. Number 2 would be what? Eminent domain. Eminent domain by means of condemnation. What's another way? How does the government take over rights of ways? What's that?
Is that police power?
Not police power.
It's like
Inverse condemnation. Yeah, inverse condemnation. That's how the government condemned all of our airspace, 500 feet and higher above our houses. How they take over rights of ways is with inverse condemnation. That's also how you fight eminent domain. It's the opposite of eminent domain. So again, water usage, eminent domain, inverse condemnation, and the other way we use condemnation is for an old beat up building, you tear it down. I use the term blighted building, just because of the alliteration. Blighted building. An old beat up building, you just tear it down because it's no good anymore. So those are the 4 uses of condemnation in Colorado. Water usage, eminent domain, inverse condemnation, and a blighted building are the 4 ways we use condemnation in Colorado. Okay. Any questions about this?
Yeah, what was the first, since there was 2 types of wells, the
2 types of wells,
household use only,
domestic well and a household use only. And of course a commercial well, but those are so rare. Domestic and household use only are the ones that you're going to be dealing with in your practice.
What uses the least water?
Pardon me?
What uses the least water?
What uses the least water?
Yeah, isn't there a question like that?
Well, the one that gets the most priority, of course, is always going to be household. Is that what you mean?
I thought I asked what was what uses
The least would be recreational.
Right.
Always, always. Because recreational, it's not even a water use, it's just available for recreation more than anything. Okay. This next chapter talks about brokerage relationships, and of course it talks about agency, transaction, broker. We've already kind of beaten it to death, but this is good review again. Let's take a look at it on page 15-2. In out? Okay. See you on Tuesday. Remember, Monday's holiday.
Yeah. Okay.
Now we have the real estate brokerage basics. We have a 1-person firm, and that's what? A 1-person firm, become an independent broker. Then we have multiple persons firms where we can have designated agency, confidential information, supervision. Let's look on the middle of page 15-3 and look at this E here. E here. Interoffice relationships. As a result of the designated brokerage statute, a designated broker may work as a single agent for the seller or landlord, and another designated broker in the same firm may work as a single agent for a buyer or tenant in the same transaction. And this designated brokerage arrangement does not create dual agency for either of the brokers, the employing broker or the brokerage firm. There it is. We talked about it. We've been talking about it for 2 or 3 days. There it is in black and white. Remember when we had Olivia and Jay buying and selling that property, listing it, selling it, and I designated them to be the brokers, and I've created for myself no agency. There's a question or two on that state exam about that. Don't miss those. Don't miss those, because they're tricky. And then we have agency, and look at the last paragraph here. It breaks down all agency falls into 3 categories: universal agent, general agent, and special agent. A universal agent is where I can act as if I am that guy. I can buy and sell everything he has. That's a universal agent. A general agent is where I'm a property manager. I'm just managing his properties as a general agent. And then I have a special agent where I'm just selling his house. Also could be a single agent. I'm just selling his house. I'm not working both sides of the deal.
So when you do you buy a property yourself, you just do an agency agreement with yourself. Is that how? That's how I've always done it before.
Doing an agency agreement with yourself.
Like a buyer's agency. How does that work?
Well, you don't do an agency with yourself. You just put down in the MLS agent owned, if it's your own house.
No, what if the agent is buying their own property?
If the agent is buying their own property,
Yeah.
they're not. Why would they wouldn't be using me?
No. Like, so suppose I'm a licensed agent and I wanted to purchase my own property, but in order to, no,
Like you go out and buy a
I
property.
buy an investment property.
Mhm.
So the way I've always done those agreements for, like,
Oh, I see.
who I worked for in the past,
You're
I would
your own
always,
buying agent?
yeah. Is that how you do it?
You're your own buying agent,
Yes.
and you are,
Okay.
because you're not working with another broker. You're your own
So you,
agent.
Right.
you fill out that slip with yourself then?
So do a whole buyer's agency with yourself?
Oh no,
No.
no,
Okay.
no. All
That's
you
a good
put,
question.
you just put in the contract that the purchaser is a licensed real estate broker for the state of Colorado.
So then a buyer's agency is not gonna be required then for that?
No. What you're responsible for representing yourself, and so if you screw up, you can sue yourself. You know, that's the only reason you're trying to get the pecking order of how everything works, and of course you're always looking out for your own best interest. That's understood. So agency happens automatically when we're dealing with our own properties.
I really hate those what if questions, but I'm gonna ask one. Okay,
Okay.
so we'll use her example, kind of. Say she was getting ready to sell her own house, and I had a buyer. Hold on a second, I gotta figure out the scenario in my head. No, I take that back. She's gonna buy a house, and she's an agent. Would the seller's broker, the seller's broker isn't gonna have anyone to split a commission with, so how? Do you see what I'm talking
The
about?
seller's broker, sure he does. He has to pay. Okay, I'm going to buy this house. This is how I buy my houses. I'll buy this house, and I'll offer him $200,000. Okay, and a 2.8% co-op or whatever. Okay, with it, and I'll just put it in there, and I'll say purchaser is a licensed real estate broker for the state of Colorado, and they'll come back and they'll say, okay, we'll not accept 200. We want 210. They counter me at 210, or what? I'm just using figures, okay? So when it comes back to me at 210, I accept that offer. But what I do is I knock my commission off of that 210 and tell them they don't owe the co-oping fee. And so I'm bartering that fee, essentially. So they're actually paying it, but they're just taking it off the price of the house.
Cool.
So that's how you want to work something like that.
That's just a
So-
weird thing.
Yeah, but see, that's when you're got your own company. You know, your
Yeah.
broker's not going to let you do that.
No.
Okay, you got to make up the difference. So, again, just you know how to function. And very bottom of that page, 15.3, the last line talks about that express authority. We have to have agency expressed in writing. We've talked about that many times. Let's skip over to page 16.1. 16.1. Talk about listings, and we've talked about listings and how we handle listings. We went over the listing contract the other day, exclusive right to sell listing contract. Let's look at the very top of the page, 16.1, where it says a real estate broker has traditionally acted as a special agent authorized to conduct a single transaction for a buyer or seller. The broker's authority as a special agent for a seller is to find a purchaser who is ready, willing, and able to buy the single listed property, either on the terms set out by or acceptable to the seller. As a buyer's agent, the broker must locate a single property acceptable to the buyer. The broker on occasion may be a general agent, such as when employed to manage a leased property over a long period of time, collect rent, hire custodial help, contract for repairs. You're going to see a question on the state exam about general agent. And again, essentially a property manager usually is considered to be working as a general agent. And as an alternative to acting as an agent for one of the parties, a Colorado broker may be engaged as a transaction broker. In fact, it is legally presumed that a real estate licensee in Colorado is acting as a transaction broker unless there's a written agency agreement between the broker and the buyer or seller. And we've talked about that. That's our default provision. If we don't say how we're working with a person, we're automatically working as a transaction broker. That's one default provision. What's another default provision we've talked about?
Warranty,
The what?
general warranty.
Yeah, I don't think we mentioned that. But in Colorado, if we don't put down what type of deed we're using, it will default to a general warranty deed automatically. There was another default provision we talked about earlier today. How do we take title in Colorado? The three ways.
Severalty, joint tenancy.
Severalty, joint tenancy,
Tenancy and common.
tenancy in common. If we leave that line blank in the contract, it will default to
Tennessee and
Tenancy and common.
tenancy in common. Good. Those are the three default provisions that we're talking about. Again, in Colorado, if we don't put in the contract, it'll default to those three things automatically. Okay. Right to sell agreement. Let's go down to that first paragraph there, 1, 2, 3, 4, 5, 6, 7 lines down. We talked about this in other places. Commission Rule E11, far left there. Commission Rule E11 requires that all written listing contracts provide a definite date for termination. The state likes to use the word expiry date. We have to have a definite date of expiration. We cannot have this listing lasting from October 8th until sold. It has to have a definite ending date. Now, look at that second to last paragraph down there in the last sentence on the right hand side there where it says a prudent broker makes employment and its associated payment a certainty only by securing a signed listing contract. I have a friend of mine who, she went over to this friend of hers house and they were sitting there having dinner or whatever, and he said, I'm thinking about selling my place. And she said, really? She said, I've got a buyer for it. Why don't you list it with me and I'll sell that sucker right away for you. And he said, cool. He said, mail me the stuff. So she mailed him all the stuff, the contracts and everything, and he sent them all back. He signed everything except the listing contract. And so she called him up and said, hey man, you didn't sign the listing contract. He went, oh shoot, well next time we're together. Well, he never did sign it. And she sold that house and it went to closing. He owed her like $10,000 and paid her $2,000. And she said, what can I do? And I said, hey, without that listing agreement, you're lucky you got the $2,000. So I'm suing him, blah, blah, blah. And she couldn't even get a lawyer to take the case. And the funny thing is, I know both these people. I know them pretty well. And I know for a fact that he asked her to marry him about 2 years before that, and she said no.
Oh.
So a little bit of payback going on there, I think.
Wow.
So,
Sorry for the ring he bought.
Thank you.
okay, see you Tuesday. Have a good weekend. You gonna keep coming?
Yes.
Cool. Guys, and keep coming. Whatever it takes, if you need to keep coming to these classes. You have a year to complete this. Take this class 10 times if you want to. So, but usually the second time through you're going, I am getting this a lot better than I thought. You really will. So, let's go to top of page 16.2 and talk about the different types of listings. A net listing. A net listing is where I subsidize the owner's expenses. A net listing. A net listing is where I have a set amount plus I'm paying the utilities. That's a net listing. I have a set amount and I'm paying the utilities and taxes. That's a net listing. I have a set amount where I'm paying the utilities, the taxes, and the upkeep. That's a net or triple net listing. That's a net listing, and the main thing about a net listing is I'm subsidizing the owner's expenses. Then I have an open listing. An open listing. That's where I list with.
Other
Oh, I'm
brokers.
sorry, guys. I'm talking about
I'm talking about leases.
a net lease. Boy, I'm off it. Okay. It's been a long
Oh.
week. I just like described a net lease. Okay. What's a net listing? A net listing is where they tell us that they only need $200,000 or whatever, and anything I sell for over and above that I can keep. That's a net listing.
When I lived in Mexico, people did that a lot.
A net
And they
listing.
did a lot with open listings also. It was not good.
Well,
There was no MLS.
Well, that's why you would have it. There's no MLS. Open listings are the only thing that really work. You list it with 20, 30 brokers.
Yeah.
Yeah.
Oh.
And then you have an open listing where there again you list with about 20 or 30 brokers, and you'll never do that in Denver
No.
because if the seller sells it, you guys don't get paid at all. And do you really have any incentive to sell that property? Where if I get an exclusive agency or exclusive right to sell, I throw in the MLS and I expose that home to thousands of brokers. So again, that's what you're going to be using, is down that last paragraph, an exclusive agency listing. Above agency, put broker listing. Exclusive broker listing. And this is where no matter who sells it, you get paid unless the seller sells it himself. And nobody gets paid. And again, that's an exclusive agency listing. In Colorado, sometimes it's called exclusive broker listing. Same thing. Top of the next page, exclusive right to sell listing. This is the one we did in class, line by line. No matter who sells it, we get paid, even if the seller sells it himself. That's the one you're mainly going to be using. Then multiple listing services is just where we market it through. And then the right to buy agreement, then you can actually have someone with a buyer agency where no matter who sells them a property, you get paid. Let's go to the top of page 16.4 and talk about a change of status. Change of status, top of page 16.4. It says a broker may not represent one party as an agent and work as a transaction broker with another party in the same transaction. The principal to the agency agreement may agree to revert to transaction brokerage. To accommodate this change, the commission listing forms contain a selection by the client at the time of the listing and a change of status form to notify the client at the time the double-ended situation develops. When do we present this change of status? When the change occurs. When does it occur? At time of contract. Remember, I have agency with both parties. What something has to give. That change of status letter changes that purchaser either into a customer or changes both parties to transaction broker. Let's go to page 16.6. See if you remember this. Right below that second paragraph there. How do you finish this statement? Closing instructions do what?
The closing.
Remember that word? Closing instructions engage the closing entity or the closing agent. Closing instructions engage the closing entity or agent.
Say it again.
They engage the closing entity.
Closing instructions.
The closing instructions, yeah.
The word engage is going to be on the test, is what
Yeah,
you're
that's the
saying?
word they use. Engage. Yeah.
Engage. I'm sorry, I'm bad at this. What?
You're not bad.
Closing instructions, right there.
I wrote that.
Yeah.
Closing instructions engage.
Engage the closing,
Closing
entity,
where the closing
or it could say the closing agent. Either
yeah,
one on
where
the
the closing will
same.
take place.
Yeah. And then on page 16.7, kind of right in the middle there where it says commission approved seller's listing contracts require the consent of the seller before a broker may offer commission splits to cooperating brokers. Put a star by that. We can't even pay a co-op without that seller's permission. Okay. Let's go to chapter 17, guys, and look at the contracts again. You know, in the state exam, there's more questions about contracts than any other subject. On the Colorado portion of the state exam, there's 22 questions. There's only 74 altogether. 22 of them are on contracts. On the general portion, you're going to have 10 questions on contracts, so 32 questions on contracts. If you blow the state exam, you blow it because of contracts. So that's why it's so important that we get these contracts down so steady, so well. Let's go to 17.1 here. Look at the introduction on top of the page. Together with the laws of agency and brokerage relationships, an understanding of contract law is essential for real estate practitioners. A licensee constantly reviews contracts for purchases, lease agreements, and mortgages. In Colorado, real estate licensees are allowed to fill in blanks in standard contract forms. The competency and professionalism of the real estate licensee are always at stake when contracts are being written or explained. Of all legal instruments, contracts are among the most important to our society and economic system. The stability and security of our business world are dependent upon the law of contracts. It ensures that parties perform their agreements by requiring that they either perform or pay for all loss or damage caused by non-performance. Furthermore, the specialized branches of business law, such as the sale of goods and services, negotiable instruments, partnerships, and corporations, are all founded upon the law of contracts. And this is one of the best definitions I've ever seen of a contract. It says a contract may be defined as an agreement between two or more competent persons having for its purpose a legal object wherein the parties agree to act in a certain manner. Very good definition. Now, the elements of a contract are mutual assent. Above that or somewhere on the side there or above mutual consent, write these down. Mutual consent, these all mean the same thing. Mutual assent, mutual consent, meeting of the minds, mutual assent, mutual consent, meeting of the minds, and mutuality. Mutuality. Mutual assent, mutual consent, meeting of the minds, and mutuality all mean the same thing. We're all acting in good faith.
There's a question of sense that talks about offer and acceptance. I mean, it's the same, or
The offer and acceptance,
Yeah.
isn't that a meeting of the minds? That's a
Uh-huh.
perfect example. Yeah, that's a meeting of the minds, isn't it? The offer and acceptance. You're offering me your house, and I'm taking it. You bet. And we have the parts of a contract. Of course, we have the offer. We know what an offer is. It's a promise by one party to act in a certain way. We have an offer in the bottom of page 17.2, acceptance. The offer and acceptance. That's when we have a contract. When we have the offer and the acceptance of the offer. And then on page 17.3, 17.3, we have the, where it says reality of consent. Look at the statute of frauds here. Let's start a 5 lines above that statute of frauds, where it says fraud and misrepresentation are self-explanatory, and when present, permit the innocent party to cancel the contract and in appropriate cases to recover damages. Remember, fraud is voidable. Not void, it's voidable. Undue influence consists of the abuse of the control or influence that one person has over another because of their relationship. Duress consists of compelling a person through fear to do or to agree to do an act. And then the statute of frauds, totally different than fraud. is to prevent fraud through perjury. The law requires that the parties' agreement evidencing their mutual assent be in writing in certain cases. As to the real estate in Colorado, the state statute provides that every contract for the leasing for a longer period than 1 year, or for the sale of any lands or any interest in land, is void unless the contract or some note or memorandum thereof expressing the consideration is in writing and subscribed by the party by whom the lease or sale is to be made. The statute of fraud purpose is to prevent fraud, but it in itself is not fraud. All contracts for real property in Colorado must be in writing or they're void through the statute of frauds. And the one exception are leases for a year or less. May be verbal. Okay, let's go ahead and take a break. So let's do this. Let's go to page 17.3, and let's look at the statute of frauds. Statute of frauds. To prevent fraud through perjury, the law requires that the parties' agreement evidencing their mutual assent be in writing in certain cases. As to real estate in Colorado, the statute provides that, this is what the statute of frauds reads: every contract for the leasing for a longer period than 1 year, or for the sale of any lands or any interest in land, is void unless the contract or some note or memorandum thereof expressing the consideration is in writing and subscribed by the parties to whom the lease or sale is to be made. So again, this is to avoid fraud in verbal contracts. You can have a verbal contract to sell your car, to sell your bicycle, but anything that has to do with real property has to be in writing or it's void through that statute of frauds. And that's different than fraud itself. Remember, fraud is voidable in a contract by the injured party, but the statute of frauds makes it void if you have a verbal contract. Everybody clear on that? Okay. Let's go over to page 17.4 and the old parole evidence rule. We just talked about that in the sales contract, or we're going to talk about it if you haven't had the sales contract yet. We had this in the listing contract, the parole evidence rule. Parole means word or speech. It means if we had a verbal agreement and it didn't make it into the contract, it never existed to begin with. The parole evidence rule. Then we talk about consideration. Here it is in black and white, second paragraph. Consideration may be defined as a promise or an act of legal value bargained for and received in return for a promise. What is consideration? Something of value. Something of value. Very subjective, something of value. And then number 3 up here, another part of the is competent parties. Let's read this. This is kind of interesting. Competent parties. All parties are presumed to have the legal capacity to enter into contracts, but certain persons, for reasons of public policy or some disability, do not have full contractual capability or capacity. Among those are minors, mental defectives, and intoxicated persons. In Colorado, a minor is an individual under 18 years of age. Minors have the right to cancel or disaffirm their contracts with no liability other than the return of any proceeds they received under such contract. Like if you sold your car to a 16-year-old, they could drive it for a year, actually 2 years, come back and get all their money for it if they wanted to. It's voidable by people under 18. Minors are given this right to protect them against their lack of experience, judgment, and ability. The burden is upon adults to ascertain that the person they deal with is of legal age. After reaching legal age, minors may ratify or approve previous contracts, which will then be binding on them. And of course, the exception of that are when these minors are emancipated. And there's 3 ways they can be emancipated. They can join the service, they can get married, or their parents can have them emancipated. Any questions on that? Just kind of remember that word emancipation. And insane persons are given the same protection as that given to minors, except that the contract of a person judicially, through the courts, declared insane could never have had effect in the first place. Remember, judged by a court as insane, it's void to begin with. By a doctor declares you insane, it's voidable by that person. And I can say that again. You guys understand that, okay? By a court, void to begin with. By a doctor, voidable. And the contract of an intoxicated person is usually binding, except that person is, unless where that person is so intoxicated as to be incapable of understanding the nature of the transaction. In that case, the intoxicated person may cancel or approve or ratify the contract. Isn't that something? Who makes that decision? You're at the closing and you have somebody in there who's plowed out of their mind. Who's the one who's going to call them on it? How do you do that? And usually it's done by that closing person who's sitting there.
Yeah.
And you might go up and say, hey, you notice this guy over here, man? You know, not looking good. So again, it's up to you guys to kind of keep an eye on that. And does this happen? Not often. Not often. It only happened to me one time. It was about a 9:30 closing. It was really early in the day. It was 9:30, 10 o'clock closing. And this one guy showed up plowed. And fortunately, this closing lady, instead of doing it for the next day where all the figures had changed and everything, fortunately she's changed it to 4:30 that afternoon. And by then, I was totally sober. So the next one. A corporation's charter determines its contractual ability. Its capacity to contract may be related only to specific things or may be related to broad areas of business transactions when you're dealing with corporations. And then we have legal purpose. To be valid and enforceable, a contract must have a legal object for its purpose. If it's for an illegal purpose, it's void to begin with. We're on page 17.5 of the manual. To be valid and enforceable, a contract must have a legal object for its purpose. The object cannot be to violate a valid statute. An agreement to commit a crime or tort. Let's spend a minute on torts. You're going to see that word. A tort is a private wrong. You don't go to jail because of a tort. It's just a private wrong. An automobile accident. It's something you could get sued for, possibly, but it's a private wrong, something you do in a private situation. A term that you want to write down, which is kind of a cool term, is tortious malfeasance. Tortious malfeasance. That's where you have committed a tort of some kind. And tortious malfeasance, something that you could get sued for, possibly. Tortious malfeasance.
Fraud.
Fraud. Fraud is something, of course, could you go to jail because of fraud? Possibly. It may go beyond a tort. But yeah, most fraud is tortious. I mean, you had somebody sign on a contract when they didn't have the full information or the capacity to know that if they were signing was correct or not. A tortious malfeasance. And matters to be considered in real estate contracts, let's read this. The buy-sell contract is the most important document in a real estate transaction. This contract determines the kind of title to be conveyed, the type of deed, liens and encumbrances that the land will be sold subject to, and the manner of payment of the purchase price. Numerous controversies involving real estate licensees arise out of contracts for the sale of property. These few paragraphs here are dynamite. Really good paragraphs. Although dishonesty or wrongdoing on the part of the licensee is rare, disputes often stem from the licensee's lack of thoroughness or knowledge. Real estate brokers must continually strive to increase their own proficiency and that of their employed licensees in writing good contracts. It is an art to write a sound, workable contract and include all important matters and is still reasonably clear and understandable. Although Colorado licensees are fortunate in having commission-approved contract forms available, they must nevertheless pay close attention to completing these forms in a competent manner. All we're doing is filling in the blanks, for the most part. But even with that, the perfect contract has never been written, never will be written, because there's always ways to improve it. What do we have to do? That contract has to be legible and understandable. And we're so fortunate. I get people from every state in here getting their license, been licensed in every state. And some people come in, they tell me just horror stories where in some states they have different contracts for different counties in the state. Weird things like that. You know, we have this monster, this 16-page sales contract. I don't know of any state that has a 16-page sales contract, but all we're doing is filling in the blanks. Not too shabby, not too shabby. You know, and a fourth grader could understand that contract. There's not a lot of legal garbage in there. You can read it and understand it fairly accurately. And then the following are the main items to be considered in drawing up real estate contracts. This list is not intended to be exhaustive, and seldom are two real estate transactions alike. Only through careful study, experience, and guidance will the real estate licensee learn to recognize the essential items to be included in a given transaction. You have to have the names and signatures of the parties. Now, this list for what creates a contract is the same list that what creates a deed, what creates a listing contract. Once you know one of these lists, you pretty much know them all, with very few exceptions. You get one list down, you got them all down. Sale price and payment provisions, the description of the property, the type of deed. How are we doing with deeds, guys? You getting that down pretty good? It's really impressive when you're out there dealing with your people and you know how to explain deeds. Plus, it's important to you when you're buying your properties too, knowing which ones to get. Are there any questions on deeds now that we're talking about it? Anything in particular? Anything you're stumbling over or need clarification on? Good. So it's there. They must be coming then, hopefully. Then we have condition of title. The condition of title. What are the conditions of taking title? What are the two remedies? The default provisions, the penalties. 2 weeks before closing, I changed my mind and I don't want this property. What are my two penalties? Liquidated damages, which means what?
You lost your earnest money.
Lose your earnest money. Very good. Liquidated damages, and the other is specific performance. The seller can force the buyer to buy. If we give them that power, remember I showed you that in the contract where I don't give them that power over my buyer. I don't want this ending up in court where I'm stuck in court and I can't find my buyer another property because he doesn't want to buy it. The seller has to take him to court. So I want the remedy to be specifically liquidated damages, personally, whatever your broker wants you to do. If you buy a new home, they'll always make that a condition where the seller can force the buyer to buy. Remember that. So we have liquidated damages and specific performance as the default provisions. Contingency provisions, and we have a ton of contingencies in these contracts, don't we? And we really don't have a contract till all those contingencies are taken care of. That goes back to a ready, willing, and able purchaser. Because he signs the contract, he's ready and willing. We don't know if he's able until all these contingencies are met. And we don't have a contract until those contingencies are met. Then possession. When does he take possession of the property? And that's going to be more and more of an issue. And apportionment or adjustment. Those of you who've had closings know all about prorations. And risk of loss. Remember I mentioned that in many states, between contract and closing, if something happens to that house, the buyer is liable. Isn't that crazy? Let's read this. If the property is damaged or destroyed by fire, flood, or storm, After the contract is signed but before the deed is delivered, who suffers the loss, the seller or the buyer? The answer is not as simple as it seems. In most jurisdictions, when a binding real estate contract exists and where either party may enforce specific performance, the loss falls upon the buyer, who is considered the owner of the property. The buyer holds what is known as equitable title. Isn't that what we get at time of contract, guys, in Colorado? At time of contract, we get equitable title. Then when we close, we get legal title at that point, because that's when we get the deed, is at closing. The buyer holds what is known as equitable title. He got that at time of contract. Even though legal title is not yet passed, the buyer can legally force the seller to convey the legal title. Also, the seller can force the buyer to accept the legal title and perform their part. This right is called specific performance. The parties lose this right only if they waive it in the contract. And we did waive it, didn't we? Some courts interpret equitable title theory as unjustly putting the burden of loss on the buyer. Well, yeah. Not being in possession, the buyer is unable to protect his or her interest. Then my least favorite word, however, which has canceled all that out. The majority of courts seem to hold that the loss falls on the buyer, unless the contract says otherwise. And what's our contract say? It says that if it's less than 10%, the seller has to fix it before closing. And if he doesn't, the buyer can take his money and leave. Or if it's over 10%, this buyer can take his money and get out of the contract if he wants to. Or the seller can agree to fix it before closing, or get the insurance to commit to do it.
10% of the
Before
value
closing.
of the loan or the
Of the value of the
purchase price?
property, thank you. Not 10% of the value of the loan, value of the property itself. 10% or less, the seller has to fix it before closing.
And
So-
it's not negotiable.
It's not, everything's negotiable. Everything's negotiable. What's the contract say? And can you adjust that contract?
Yeah,
Sure you
that's-
can. Sure you can. I really want this house.
So
Really
it's not
want
a
this
state
house.
mandated contract then.
Oh no, it's not mandated. That's what it says in there though. Because if the damage is 10% or less, the buyer can agree to take the house, or he can take his money and leave, or he can force the seller to fix it.
Okay.
So the contracts are very, very much in the buyer's advantage, as well it should be. As well it should be. Because like they're not living in the house. They have no way of protecting their interests. And then, of course, we have a contract to buy and sell. That's what our contract is called in Colorado, is the contract to buy and sell. Every state has a different name for their sales contract. And are there any it talks about here about time is of the essence, which means what? These dates are strictly enforced. Remember that? You're going to see a question about that. Time is of the essence. It means these dates are strictly enforced. And then, of course, the two remedies for default, specific performance and liquidated damages. There they are right there. Any questions about those?
What if, for some odd reason, the seller just decides he doesn't want to sell the house?
What would happen if the seller just decides he doesn't want to have to sell it, doesn't want to sell the house? The buyer can always force the seller to sell. But see, it has to go through mediation, it has to go through the court. All of a sudden, we just got this mess out there. And it does happen. I've heard of it happening more than once. It doesn't happen often. But there was this one guy, this friend of mine, she and her broker had this one deal, a $650,000 house anyway. The house was going to close on a Friday, if I'm not mistaken, and the seller called them up on Monday and said, I don't want to sell my house. And my buddy, my broker, my friend said, hey buddy, you don't have a choice. My buyer can force you to sell. Remember, the buyer always has specific performance. And so the next day at 7 o'clock in the morning, he went over there and woke the people up and scared the heck out of them, and they canceled the contract. And so then he went and talked to his attorney. And this attorney told him, are you nuts? Now you owe this brokerage firm, it was like $42,000, and now you chased away the buyer. So he goes and talks to my buddies, the brokers, with his hat in hand and saying, please just put my home on the market and sell it again. And they said, no. You're a flake? They don't know if they said that, but we're going to, and we're going to come after you for the $42,000 we owe you. So they set up mediation. And a couple days before the mediation, he called up and he said, I don't want mediation. I want to go straight to court, get this settled. So now he's going to have court costs and attorney's fees on top of the $42,000. Not real bright. And he couldn't even find an attorney to take his case. It was so bad. And so finally they did go to mediation. They got just about the whole $42,000. And so anyway, yeah, like I say, the buyer has all the marbles, guys. As well they should. So, look on page 17.9 and look at that fourth paragraph. Earnest money deposits. We keep talking about this earnest money. And like I say, in the contract we did, all we had was a promissory note. I don't like that. Don't like that promissory note, but sometimes it's necessary. Just make sure you don't let them play games with that promissory note. Make that due in 3 days, 7 days at the outside. Like I say, you're going to make the mistake, and I've made it, where you just say, I'll just bring it to closing. I'll tell you what, every time, I know that one time I did it for sure, that deal fell through. And it will. Count on it falling through. If they can't come up with that money before closing, they're not going to come up with it then either. So earnest money deposits are another critical element of any contract. Earnest money should be adequate to demonstrate the buyer's serious intent to purchase, and in the event of a buyer's default, to compensate the seller for the act of taking the property off the market during the period prior to closing. Earnest money should apply only to partial payment of the purchase price. The form of earnest money, check or promissory note, big star, must be specified in the contract. Where do we find out about the earnest money? How it was paid, how much it was? It's in the contract. How do we find out what the co-op is? It's in the contract. How do we find out how we handle showings? It's in the contract. All of these questions they're going to hit you with like that. It's in the contract. It's contractual. If it is a note, it must have a definite due date. The Commission strongly recommends that notes not be taken with due dates of at closing, just as we talked about. Such notes create confusion as to the seller's forfeiture rights if closing does not occur and the buyer is in default. The Commission-approved buy-sell contract includes a mediation clause by which the parties agree to submit the matters in dispute to mediation when the dispute cannot be otherwise resolved. Mediation is non-binding. Remember that? It can be if the parties agree, though, right? If efforts of mediation do not resolve the dispute within 30 days of the written notice requesting mediation, the mediation terminates unless the parties mutually agree to continue. Then it flips over from mediation to arbitration, then litigation. The 3 steps: mediation, arbitration, litigation. And remember, arbitration and litigation, there are attorney's fees. And what's that word? The prevailing party is awarded attorney's fees, which means they don't have to pay them. Then the next page talks about loan contingencies. You might have contingencies on the loan. The assumption, we haven't had assumptions since 1990. We're going to start seeing them again once the interest rates start going up. And then we have buyer's creditworthiness. The next page, a balloon payment. We really don't have loans with balloon payments anymore. Those were adjustable rate mortgages for the most part. When we get into financing in the law and practice portion, we talk about that in greater detail. But we have the roll and the adjustable rate mortgages where it rolls over after 3 years or 7 years or 10 years, whatever. It might roll over after 1 year. And I used to say that we had a balloon payment because they called the whole amount due. Well, now we really don't have a balloon payment. It just rolls over into another adjustable rate mortgage for the most part. Then surveys. Let's read this. Many properties have not been properly surveyed. This is true particularly in areas that have not been formally subdivided into platted parcels. Some subdivided areas also contain irregular lot sizes, and the survey may be questionable. Both the frontage and running feet and the acreage, which determine square footage, are important, and both should be verified before quoting figures to a buyer. In some cases, improvements such as fences or garages encroach on boundary lines, and only a survey will reveal the problem. A broker may be liable in such situations because brokers are assumed to have greater knowledge than that of buyers and sellers, and the broker should recommend to both the buyer and the seller that a survey be made. We talked about that. But we're usually overridden by the lender or the title company. They say we don't need a survey. Dual contracting. That's where I have two contracts. One's legitimate and one's phony. I use the phony one to get a deal. Installment contracts. What's some other words for installment contracts?
Contract?
Land contracts, installment land contracts, owner will carry, contract for deed. All those mean the same thing. This is where the seller becomes the lender and actually carries back the loan. I'm selling my home for $200,000 that's paid for. I can take that $200,000 and throw it in the bank at 0.5%, or I can loan it back to my buyer at 8.5% and have the property as security. You'll run into these. You'll run into these owner will carry deals, guys, and they're nice to put together. Whenever you have trouble getting a deal through, look to the seller for help. Look to the seller for help. The next page talks about an ILC instead of a survey. We all know about that. Let's go to page 1715. And real quickly, we kind of mentioned, we don't get into a lot of detail on manufactured housing because there's so many different types of it now. But one thing about manufactured housing, remember that a modular home that's sitting on a perimeter frame, you can sit on a basement, you can sit on a crawl space, they're financed just like stick-built homes are. And you can interchange them. But if I'm doing an appraisal on a home like that, I can actually use stick-built homes as my comparables or vice versa. So remember that. Manufactured homes and mobile homes are considered, they're synonymous. They mean the same thing. A manufactured home is again, if it's sitting on a perimeter foundation, it's not a mobile home. And mobile homes are completely different animals. So again, remember these modular homes. Modular homes are financed just like regular homes are. You're going to start seeing more and more of them. Also, prefab homes, you'll hear them called that. There's a lot of different names for them. Okay. That is the end of lesson day 6, and we'll pick up on day 7 will be the buy and sell agreement, and then we'll pick up on lesson 8.